welcome. In this video, we are going back to the Tyre Nichols case. Now, if you've seen any of my other videos, you know that I've been tackling this prior alleged complaint that had been filed against Officer Demetrius Haley, former Memphis police officer Demetrius Haley. He has since been dismissed. We all know that. But there was this prior complaint that had been filed. In this video, I'm going to dive a little bit deeper into why I think the fix was always in. It was always going to be hard for Mr. Sledge, the person who was alleging that Officer Demetrius Haley had punched him in the face, why it was always going to be hard for him to move that case forward. And go ahead and give the video a thumbs up if you like where this is going. Yeah. Again, welcome to the video. So let me backtrack just a little bit for those of you who are not completely on board yet and up to speed with what I'm talking about. Demetrius Haley is one of the former Memphis police officers who was dismissed because of what was going on at the scene, where he was one of the officers that was involved in what happened with Tyre Nichols. Now, we now know that there was this prior complaint for an incident that happened in the Shelby County Correctional Center, I think is where that happened. He was a corrections officer at that time. This was back in 2015. Well, the person who was hurt, who filed a complaint, was stating that former Officer Haley had punched him in the face, another officer had punched him, and that another person who worked there, another employee, had slammed him into a sink or something like that. He filed a complaint. His complaint was dismissed. Why? Because you've got to jump through some other hoops before you can just send in this complaint, and he didn't do that. So the first thing that I want to do is take you to what this process looks like, because once you understand that there is this process, it's not like if someone burns your house down and you want to sue them for burning your house down, you have X amount of time to go to court and sue them. Statute of limitations, we're all familiar with that. This is sort of what this is like, but it's based on the Prison Litigation Reform Act. And you can tell me whether or not you think this is actual reform. Let's take a look at this reform. And first of all, I'm going to need my glasses so that I can actually see what it is we're talking about. And I probably need to turn my phone off. Okay, here is the text of the Prison Litigation Reform Act of 1995. I'm going to scroll down to section 7 because this is the section that is most important and most relevant to what we're concerned with. And you're going to hear me read the specific part to you. It says, Section 7, suits by prisoners. Applicability of administrative remedies. It says, no action shall be brought with respect to prison conditions under Section 1979 of the Revised Statutes of the United States, 42 U.S.C. 1983, or any other federal law by a prisoner confined in any jail, prison, or other correctional facility until such administrative remedies as are available are exhausted. So let me break this down for what this means. So this no action here is basically saying you can't file a lawsuit yet, okay? You can't do that yet with anything relating to prison conditions by a prisoner confined in jail, prison, or any of these correction facilities until administrative remedies are exhausted. This is sometimes referred to as the exhaustion requirement. Let me pop back over here so you can see me. Yes, this is sometimes referred to as the exhaustion requirement. You guys, if you've ever seen a manual for a prison, then you might understand why some people might feel exhausted just trying to figure out what they're supposed to do in order to be able to take advantage of the rights that they have. And I'm not trying to be funny with that. I'm serious. If you've ever looked at government policies, you know that sometimes it can be hard to understand what exactly it is you're supposed to do. In this case, the prison has to have some sort of grievance policy for the prisoner to follow. let's see what happened directly with Mr. Sledge's case. Mr. Sledge is the one who was alleging that Officer Haley struck him in the face. I'm going to go directly to the order so that we can see the order, because that sort of lays the piece out. This was how Demetrius Haley was able to get the whole thing wiped away. And what I want you to understand is this was not anything special. This was not anything special for Demetrius Haley. This is something that any officer could take advantage of. And I hate to sound like they're getting over on the system. What I'm trying to say is this is something that's already in place. This is a law that is already in place. All Officer Haley did was have attorneys who knew what to do. But I want to take you directly to it so that you can see the order that the judge used and how what I just read you played into Mr. Sledge not even being able to bring his case forward. So here's the order. And let me make sure you guys can see it well. Okay, so this is the order that the judge signed. And you'll see there it says order granting defendant's motion for summary judgment. Okay, the rest of it has to do with something else, so it's not important. But this is what I want you to understand here. It says, before the court is the motion for summary judgment of defendants David Dyson and Demetrius Haley. So this is Demetrius Haley saying, hey, we think this should be dismissed. This is a motion for summary judgment. We think this should be dismissed, and here's why. It says plaintiff Cordarlrius Sledge filed his pro se complaint, meaning he filed it on behalf of himself. He did not have an attorney file this for him, alleging defendants, Demetrius Haley and the other person, corrections officers at the facility in which he was imprisoned, violated his civil rights. Defendants now seek the dismissal of all claims brought against them in that complaint because plaintiff failed to exhaust his remedies as he was required to do under the Prison Litigation Reform Act. Okay, that's what I just read you. Remember, that act said you had to exhaust all administrative remedies. What is it that Mr. Sledge didn't do? He was required to submit a grievance to the prison under their policy, which said, hey, you need to submit it to us in writing, sign it, and go through that process, and you need to submit it within 30 days. He did not check the box on all of those. So once he didn't exhaust the remedies available to him under that policy, once he didn't fill out that grievance form and get it signed. Now, he did do some things. If you go back and look at my other video, I lay out everything that he did. He did some things, but he did not meet the specific requirements. So that's why I said the fix was always in against him. If you don't know what that process is, if you don't understand what the rules are, then there you are, you're kicked out before you ever even get a chance to have what really happened heard by a judge. So whether or not he got hit, whether or not that allegation was true, it never got to be heard by a judge. Why? Because he did not check the box on getting in his paperwork signed within that 30-day time limit. So the fix was already in for him. So if you don't know what's going on, if you don't know your rights, you don't know your rules, then more than likely you're going to be tossed out of court before you ever get a chance to open your mouth in front of a judge or a jury and tell them what happened. And this is what happened to Mr. Sledge. So what I'm trying to paint a picture here of, this is not something that was special for Officer Haley. This is a requirement that would impact prisoners all across the country. Whatever the policy is for the prison that they're in, they have to jump through that grievance policy before they can file their lawsuit. And if they somehow mess up with that grievance policy, if they say they didn't understand it and so they were waiting for help, if they say they were sick and weren't feeling well and couldn't work on it, most of that is not going to help them. It is going to hurt them, because then they're not going to be following the policy. They're not going to be getting it done in time. And in this case, it was 30 days. 30 days is just way too short of a time period. Let me come back on camera so I can make sure we're close in understanding this. So that is why I say the fix was in for Mr. Sledge not to have his complaint heard. It was always going to be a challenge for him to get in front of a judge, because most prisoners don't come in with a background understanding that this is one of the hoops that they're going to have to jump through. So now that you understand, you can understand the challenges that a person is facing when they're in jail and there is something wrong that occurs. They need to reach out immediately to someone, a family member, who can maybe talk to an attorney for them to understand what their rights are, so that they don't lose those rights before they ever even know that there was this possibility of losing them. Hope that brings you up to speed. I know that doesn't make people happy. It's like, what in the world? Like, 30 days. He only had 30 days. He only had 30 days. He only had 30 days. So you think about that in context of other things that happen in your life and statutes of limitations for other things, and how long those are. A year, 3 years for some things. And in this case, you can't even get to that because you missed something that was 30 days. How fair is that? Yeah, it's not. So if that gives you more information, helps you understand a little bit more about the Prisoner Litigation Reform Act of 1995, then please go ahead and give the video a thumbs up, and don't forget to subscribe. Peace.